Hello everyone, welcome to my channel Medicine. I am Dr. Asma, MRCP UK. In this video, I am going to talk about medical law and ethical principles. To conduct safe medical practice, you must have a crystal clear knowledge regarding medical law and ethics. So now we'll start the session with discussing some basic terminology of medical law and ethics. Number one is autonomy. Autonomy is the self-rule. Patient has the right to take decision about his own health condition, and we should respect and follow patient's decision, provided patient is in full capacity. That means if the patient loses capacity, he will lose autonomy. In that situation, the treating team will act in the patient's best interest, and promoting what is in the patient's best interest is known as beneficence. And there is another word, non-maleficence. That means avoiding harm. We can explain this with an example. A patient with cerebrovascular accident who has no capacity, in that situation, insertion of a PEG tube may improve his nutritional status and aids recovery. So if you are going for the insertion of PEG tube in such a situation, you are acting in beneficence. And at the same time, this insertion of PEG tube may increase the risk of complications like aspiration, and this may prolong the undue suffering of this patient. So if you are not going for the insertion of this PEG tube, you are avoiding harm, and this is non-maleficence. And there is another word, justice. Justice is fair distribution of resource. Now let's talk about one of the commonest terminology used in medical law and ethics, medical negligence. To prove medical negligence, claimants need to prove 3 points. Number 1, doctor had a duty of care. And number 2, there was a breach of appropriate standard of care. Number 3, breach of duty of care caused harm. As for example, missed diagnosis or delayed diagnosis results in advanced stage of malignancy, which makes it now incurable one. So this is a medical negligence. To perform any procedure, you must take prior consent, and to give consent, the patient must be competent. So now we'll talk about competence and consent. According to UK medical law, individuals aged 16 and over are presumed to have the capacity to make decision about his or her own medical conditions. And there is another terminology known as gillic competence. Patients under 16 years can consent to undergo a procedure if they are deemed gillic competent. They cannot refuse the treatment. Refusal of treatment may be overridden by parent or court if it is in the child's best interest. So every human being of adult age, that is 16 and over, and of sound mind has a right to determine what shall be done to his or her own body. And in accepting patient's autonomy, clinician must be satisfied that patient has full capacity, and consent is not valid if patient has no capacity. So capacity assessment is very important, and capacity assessment has 4 points. Number 1, the patient must comprehend and retain the information needed. And number 2 is patient can understand the pros and cons of both accepting and refusing the proposed plan. Number 3 is he must be free from undue external influence. And number 4 is he can communicate his response. A patient with sputum positive or a patient with smear positive pulmonary tuberculosis and he has full capacity, he needs anti-TB medication. In such a situation, if the patient refuses to take the treatment, that is anti-TB medication, which is very necessary, and in accepting patient's autonomy as he has full capacity, you cannot force him, you cannot administer anti-TB medication. If you do so, then this will be battery. But as this patient posing a risk of infection to the public, so under Public Health Act, you can detain the patient, but you cannot treat the patient. Before performing any procedure, taking prior consent and proper documentation is very necessary. And it is advisable to tell your patient regarding all relevant information and all potential complications, even if it consists of incidence of at least 1%. Otherwise, the doctor may be found negligent. A signed consent form is not legally binding. Patient may withdraw the consent at any time. If the patient lacks capacity, and it is best practice to discuss any intended procedure with patient's relative. And this is not legally binding, and this does not constitute a consent. Now let's talk about patient confidentiality. Patient has the right to expect that doctor will not disclose any personal information that they learn throughout the course of their professional duty, unless the patient gives permission or some special circumstance. And under common law, doctors are obliged to maintain patient confidentiality, although this is not absolute. Doctor can breach patient confidentiality in certain situations and when another party may be at risk of serious harm. As for example, an epileptic patient who continues to drive. In that situation, doctor must inform the DVLO medical officer. An HIV positive patient who refused to inform his partner. So, doctor must breach patient confidentiality in certain situations and must inform relevant authorities. In case of notifiable disease, meningococcal meningitis, public health department needs to be informed. Now let's talk about another important thing, that is doctrine of double effect. This is a moral argument that distinguishes actions that are intended to cause harm versus those where harm is foreseen but not intended. As for example, the administration of morphine intended to palliate pain in a patient with terminal illness. Here, morphine may have the foreseen consequence of respiratory arrest and subsequent death, but this is not intended. And it is morally and legally acceptable, although the primary aim was to alleviate pain, not cause death. And this is known as doctrine of double effect. And there is another term known as duty of candor. It is a legal obligation for the healthcare professionals to open and honest with patient when something goes wrong with their care. And it requires providers to inform the patient about the incident and what caused or could have caused harm. Apologize to your patient and explain what happened. Now we will talk about battery. Battery is when treatment administered without valid consent. And these are the civil offense rather than criminal ones. Battery does not require the victim to suffer any injury, whereas in negligence, breach of duty of care caused harm. But in case of patients who lacks capacity, we should respect patients' wishes or beliefs, but we must check proper documentation. As for example, a patient with upper GI bleeding who lacks capacity and requires blood transfusion. In such a situation, patient's wife expresses that prior to this incident, he expressed to her that he will not take any blood or blood products. So in that situation, if the patient's condition, if the circumstance allows, and there is a possibility that patient may regain consciousness with fluids, then you can wait and the patient himself can give consent for blood transfusion. And if the patient's condition doesn't allow you, and if the circumstance doesn't allow you, then the treating team will act in the patient's best interest if patient's wife cannot provide you, cannot show you in any proper documentation. Now let's talk about LAMA DAMA paper. LAMA is leaving against medical advice and DAMA is discharge against medical advice. Patient can refuse treatment and patient can get discharged. In accepting patient's autonomy, if the patient is in full capacity, after knowing the pros and cons of refusal of treatment, he can get discharged. And for mental health assessment, you have to ask the patient about some checklist questions. Ask about whether there is any suicidal tendency or not. Ask your patient how you are feeling nowadays. Is there any sadness or any low mood? Are you enjoying your daily activities? Did you ever try to end up your life or any thought about it? If you are satisfied, then you can discharge your patient by preserving autonomy. And if you are not satisfied, and if you are thinking that the patient may require further psychiatric evaluation, then under Mental Health Act section 5(2), you can detain the patient for 72 hours. And this is the doctor's emergency holding power, and it can be applied by a physician of any specialty on an inpatient to enable psychiatric evaluation to be made, and the detention period is 72 hours. As for example, a patient with paracetamol overdose who seeks DAMA, in such a situation, if the doctor thinks that this patient requires further psychiatric evaluation, he can detain the patient for 72 hours. Now we'll talk about advanced directive of living will. It can be written by a person who has capacity and wishes to express his decisions to refuse treatment in the future should they lose the ability to express their wishes or they lose the capacity to make decisions in the future. As for example, a dementia patient, with time, he will lose capacity, so he can file an advanced directive of living will. And if the situation is life risk condition, then research the document carefully, whether it involved or whether it mentioned the circumstance in which the decision would apply. If the decision is to refuse life-saving or life-sustaining treatment, and whether it include the phrase even if life is at risk. As for example, a nursing home resident who suddenly became unconscious and there is a possible stroke who needs urgent hospitalization and further assessment. But the patient had a prior advanced directive of living will which is well documented that even her life is at risk, she will not get admitted into a hospital. So by respecting the patient's advanced directive of living will, you cannot make her get admitted into the hospital. And our doctor can be at risk of battery if he does not comply with the wishes expressed in the advanced directive of living will. Now we'll discuss about DNR, do not attempt resuscitation. According to UK law, the decision whether or not to perform CPR must be discussed with the patient. And if the patient lacks capacity, then you must check advanced directive of living will. And always keep it in your mind that DNS CPR is a decision of the treating team. The patient can refuse CPR, but patient cannot demand for CPR. And now we can discuss about another important thing, that is end of life care. And this is the most difficult decision. And the phrase omit to act, this phrase makes it most difficult to justify morally. But the two other words, that is non-maleficence and justice, comes forward. If extending the life results in undue suffering, and if trivial extension of life caused enormous monetary expense, then the end of life care decision applied. So that's it for today. If you have any queries, you can let me know in the comment section below. Stay safe, stay well.